All right, how about now? Can you hear now? Can you hear me now? Can you hear me now, everybody? I just did an amazing lecture that was definitely worthy of an award, and everybody missed it. Just kidding, just kidding. Sorry about that. Oh, yeah, I'm telling you, the switch between the talk and the tube sometimes. Oh my goodness, I'm so glad you told me. I would have just been sitting here talking to myself for the next hour. Like, oh, the chat's quiet tonight. Oh my gosh, that's so funny. Oh, goodness gracious. Okay, you can hear me now. Okay, great. Love to hear it. Love to hear it. So funny. I'm doing my best. I'm just an old Gen Xer here with like a phone and a prayer. So a little bit at a time. Ooh, goodness. But tonight should be really interesting, everybody. I've not read the defendant's answer. So this will be my first time seeing this information also. So that should be, these will be my first impressions as well. First one this time. Yay! We love it. We love it. I'm trying to get myself sorted out. There we go. Here we go. In my paper, oh my gosh, everybody, I know I blame my cats for everything, but seriously, this was Pearl. She was just sitting here on my complaint like all morning. And I came in, I was like, do you mind? And you move your furry behind to something else. Thank you. Appreciate it. She was put off by that. I'm like, oh, whatever. She did, VC. I mean it. I mean it. Seriously, she was just, oh, well, what can you do? My significant other now, whenever the cat sees something crazy, he's like, oh, look, you're being a cat again. That's great. Like, that's a good point. Hello, hello. Welcome, welcome in. Hi, Jamie. John, welcome. Good to see you. Brenda, I'm so glad y'all could join me tonight. Again, I think this is really important that we get both sides of the story. I think everyone has a good idea of how I feel about this case, which is I tend to trust and believe in the person bringing the complaint. I do, especially for these kinds of cases, but I want to hear the other side. You know, maybe Miss Lively is mistaken on a few things, and maybe she mixed up some things. So we don't really know. And once we go through the complaint, we'll be able to see what the other side has to say. So I'm kind of go through that. Hello, H. Titus, Nancy. Good morning, Carrie. Oh, cat in the box. You see, that's funny. Oh, I love it. I love it. I love it. I just, whew, it's been, all right. I feel like this week's been a bit bonkers too. Like that first week was yikes, but January is a tough month to have this kind of a person in the White House because January lasts forever. It's the longest month of the year. I swear. So it's just dragging on and on and on. It is fun. Yes. Well, oh my goodness. I'm so glad I have them though. All right. Well, welcome in, everyone. Welcome in. Let's go ahead and get started in here. Oh my gosh. Now I think we've got the volume going. Everything should be all right. So the last time, when last we were together, everyone, we continued to go through the Blake Lively lawsuit, right? So she's got about 10 different people that are all associated with the film. And here are her complaints. And I'll just take you through because this is important. This is exactly what the defendants are writing about. And they're saying, we did not violate this. So this, again, 7 counts is quite a bit. Number 1, sexual harassment. These are all in violation of California code here. So if you're looking for that, 1964 Civil Rights Act is where we get this kind of a harassment charge from. Retaliation, failure to investigate, prevent, or remedy harassment, which I think is great. We don't have this in my state. A failure to investigate, we're just like, whatever. If you're in trouble, that's your problem in my state. Oh, this is California. Next, we've got retaliation, aiding and abetting harassment, and a retaliation here, breach of contract, intentional infliction of emotional distress. We've talked about that before. This is our intentional tort, which is just a category of torts. And of course, any kind of civil wrongdoing, we call that a tort. Next up is negligence, and we've gone through that as well. There are four pieces. There has to be a duty, a breach of the duty, the causation, putting it all together, and then a remedy that the court can provide. So those are the four different elements of negligence, which is number 8. Number 9, false light, invasion of privacy, under Article 1, Section 1 of the California Constitution, which I think is really interesting, that it's actually put in the Constitution in California, because that is not in our Constitution. Number 10, interference with a prospective economic advantage. So, of course, we've got some significant negativity going towards Miss Lively right now, and it's probably having a pretty significant effect on her ability to work as an actress and someone out in the public all the time. So, these are the 10 complaints, or the 10 bits that they are suing for and looking for damages. Of course, we have multiple kinds of damages. We have nominal damages, which would be something like that $1 situation where they want an acknowledgement someone did something wrong. And we have compensatory damages, which is, I've lost this much money, or I've had to go and do certain things, medical treatment, whatever. Those are compensatory. And then we have punitive damages, and those are solely to punish the wrongdoer. We see a lot of punitive damages in those defamation cases involving Mr. Trump and Mr. Giuliani. So this is not necessarily a punitive damages case where the defendants need to be punished, but you're free to make whatever arguments you feel are appropriate in court. So that's kind of the overview here. I've read through almost all of this, everyone, so we should have a pretty good idea of where she's coming from. So that takes us then to the defendants. So after you file a petition in civil court, and again, friendly reminder that this is legal education, this is not legal advice, but we can go through and we can learn. There's a lot of learning moments here. So when you file a complaint in civil court, you set out what you're like, look, he did this, they did that, and it was wrong and it harmed me. And so next comes the answer. And the answer comes out and says, look, you're wrong. And they go through piece by piece by piece. Now that can be pretty easy if it's a complaint with just, 3 counts on it. But if you've got this many, she's got 10 listed out here, 10 different wrongdoings. And then all of these, I think it's like, how many paragraphs does she have in here before we get to the exhibits? She did put her exhibits in here, but I just wanted to get a rough idea of how many paragraphs we're dealing with. So like probably 150 paragraphs. And so they're going to go line by line, and they're going to say, we disagree, and this is why we disagree, and deny. A typical answer is just going to be, deny, 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 deny. But something that's complicated, especially in California, they have a lot more information included. So this is a great way to just look and see what's a complaint look like in civil law, what does an answer look like. So we can start going through this answer here. And let me do a sticky note. I know that's helpful over here also. So let me just grab this real quick. So this is going to be the Blake Lively case, Lively lawsuit. Here we go. And this is going to be the defendant's answer. Defendant's answer. All right. So that's what we'll be reviewing tonight, and we'll check it against her complaint. To see what she said, and then to see what his response was. So here we go. If you're interested in following this case online, here's our case number up here. The answer itself is document 37, so the petition's usually the first. In this particular case, we've got some interesting things going on. They're trying to consolidate the cases because we've got some counters going on, some countersuits going on. Also, there have been multiple letters back and forth to the judge regarding the timing of things. So we've had actually a lot of documents come in since this answer, but document 37 is what we're looking at. That's the answer here. It's 47 pages. We're in the United States District Court, Southern District of New York, and it's Miss Lively against the 10 defendants over here. And it says defendant, the agency group, PRLLC's answer to complaint. So that's, again, we have a complaint plus an answer. one of the most important things that I would teach when I was teaching was we would do a complaint and an answer. And I did teach torts and, different liability kinds of law. And so we would go through, and if we had like a products liability, one of the projects would be we'll draft a complaint and draft an answer. If it's coffee, like what? Yeah, how are you going to sue for coffee? Write it out. The students didn't particularly care for that exact assignment, but it was incredibly helpful. And they would come back later and say, wow, that was really, one of the things I needed to do. In order to practice law, you need to know how to properly write things despite what's happening with Mr. Trump, okay? Here we go. Defendant, the agency group here, hereby answers for itself alone and no others the complaint filed by Blake Lively, the plaintiff. So this again is the complaint over here. Here are the allegations being set up. Number 1, so let's just go through here and I'll show you what she wrote. So this is our introductory paragraph to Miss Lively's complaint here, all right? So she just does this intro. So on January 4th of 2024, prior to resuming filming, and then she goes through and just gives a brief overview of the people involved. So she's naming people, and she's saying, we've got some troubles. So that's paragraph number 1. So let's see what he has to say. Number 1, answering the allegations in paragraph 1 of the complaint, defendant lacks knowledge or information sufficient to form a belief as to the truth of such allegations. So, this is a classic law answer. This is really boilerplate language because for each thing in your answer, you have to say yes or no. You agree or you disagree. And so what he's saying here is that I don't even have enough knowledge to agree or disagree. So that's interesting. But we're probably going to see that a lot. So the place where we're going to get the most information is when he really disagrees with whatever she has written. So number 2, paragraph number 2, same answer. Again, that boilerplate. So we're just going to put over to the side, no knowledge. All right. Answering allegations in paragraph 3, lack of knowledge again here. And then we can move on. They're not all lack of damage, everyone's, but we do have paragraph 4, lack of knowledge, paragraph 5, lack of knowledge, paragraph 6, lack of knowledge, answering the allegations in paragraph 7. So here's our first one where he's actually going to answer. So let's take a look and see what is in paragraph 7 that he's denying. So here we go. Number 7 here, right? So he's answering the allegations in paragraph 7 and is denying them. So let's just look real quick at a couple of sentences. So we've got, in the days leading up to the film's release, Mr. Baldoni abruptly pivoted away from the film's marketing plan and types of publicity activities in which he had previously participated. What the public did not know was that Mr. Baldoni and his team did so in an effort to explain why many of the film's cast and crew had unfollowed Mr. Baldoni on social media and were not appearing with him in public. So he's denying this. He's not just saying, I don't have any knowledge. He's actually denying. So, and typically whenever you would file a lawsuit and then the answer comes in, this is how I like to kind of break it down. So I would put deny next to it so that I know he has proactively denied that particular paragraph. Hello, hello. Was it? Okay, man from the West. Hello, hello. All right, so again, we're back over to the answer here. And number 8, answering the allegations in paragraph 8, we've got another denial here. So paragraph 8 over here is talking about his intent. We kind of talked about this a little bit too, that this would be difficult for Miss Lively to prove. Mr. Baldoni and his Wayfair associates embarked on a sophisticated press and digital plan in retaliation for Miss Lively exercising her legally protected right to speak up about their misconduct on set. So he's denying this. Remember before he had just said, well, I don't have enough information, but now we're in an area where he's like, nope, that's not true. Number 9 looks like he's got a lot of bit to it. So answering the allegations in paragraph 9 of the complaint, defendant admits that Jennifer Abel provided publicist services to Wayfair and Mr. Baldoni. that Wayfarer and Mr. Baldoni retained tag that Ms. Nathan delivered a proposal to Mr. Baldoni, and that Ms. Nathan sent communications containing the text set forth in that paragraph. So in paragraph 9 here. As to all remaining allegations, defendant denies such allegations. So we have some admissions here on just the basic people's names and what they were doing. And then we have a denial of everything else. So denying the allegations, specifically denying the allegation that plaintiff obtained the communications described in the complaint through a legal process. So this is one of those moments where they're trying to say she illegally or she somehow sneakily, is that a word? I don't know. With bad faith, right? So bad faith obtained that communication information. So this is, you know, if we're going to do like what's catty and what's not catty, this is going to be a catty moment. So we'll just put that out there where they're saying, no, she, you know, snuck around, broke into the computer like Mission Impossible style and pulled out this information, including a civil subpoena, and that the communications and their context are characterized accurately in the complaint, right? So we've got quite a bit going on here with number 9. Already they're accusing her of not properly gaining this information, as well as whatever she's saying is not true. So that's a lot going on in number 9. Number 10, answering allegations. In paragraph 10, defendant denies the allegations. So again, we've got that. We'll just put a little deny over there. Wouldn't do well on a jury. No, well, you never know. Sometimes we need people that can make up words. It depends on what the trial is, I suppose. Number 11, answering the allegations. In paragraph 11 of the complaint, defendant admits to the allegations that TAG sent communications containing the text set forth in the paragraph. So we have one admission, but defendant denies all the remaining allegations in the paragraph, and specifically denies that the communications and their context are characterized accurately in the complaint. So we have an admit and a deny. So they're saying the basic pieces that she is discussing here, we will admit, but we will deny the rest of it. Over here. All right, number 10. Oops, sorry, that was number 11. Here we go. Number 12. Number 12, answering the allegations. In paragraph 12 of the complaint, defendant admits the allegations that Mr. Heath and Mr. Baldoni sent communications containing the text set forth in that paragraph. Defendant denies all the remaining allegations in the paragraph, and specifically denies that the communications and their context are characterized accurately in the complaint. And that's pretty typical. Let's actually take a look at what he's admitting to in here, okay? So initially, Mr. Baldoni expressed concerns that TAG's written plan was insufficiently aggressive to protect him. So he's admitting that. Writing to Mr. Heath and Ms. Abel, he said he was, quote, not in love with the document they sent. Not sure how I'm feeling, the protection I felt on the call, end quote. So he's also admitting that. He's admitting these words are correct with Ms. Nathan and her colleagues. In response, Mr. Heath attempted to reassure Mr. Baldoni that they had found the right people for his campaign. Mr. Heath's words, the most important part of this is how quickly they can shut things down and place stories in your favor. So he's denying the characterization of this, all right? So kind of that narrative, but it is admitting to the text here. So I think that's important. A lot of people are saying that everything is out of the context. And, you know, I mean, we can't give full context when we're filing a complaint. So he's basically just splitting this into, well, I admit those were the texts, but I deny how you're characterizing it. So with that one, here we go. Here we go. So let's make sure. This is page 6. Uh-oh, everyone. Hold on. How do I get back to page 3 again? Oh no, is my printer jacked up? Hold on. Nope, it's not. Shoo! Yikes. It's Pearl. I tell you, she gets up on my printer and tries to pull the paper out, and I'm like, dude, what are you doing? So there's no peace. All right, hold on. Just 1 second here, everybody. I'm trying to reassemble. Here we go. So number 11, and then number 12. All right, so we're in paragraph 12. There we go. Just took a minute. So we've got also answering allegations in paragraph 12 of the complaint, admitting allegations that they sent communications in the text, but denying the rest. So we have another admit and a deny here. I think I'll just I'm trying to keep my stacks separate. Answering the allegations, defendant admits the allegations that Jennifer Abel and Miss Nathan sent communications containing the text in the paragraph. Defendant denies all of the remaining allegations. Right, so this is actually pretty good, where he's starting to come through and say, hey, this text is correct, so we are admitting to it. And when we're admitting those kinds of things, depending on how they will be used at trial, that's very helpful. For example, Mr. Trump in his New York fraud case with Miss James, when they sent out their complaint, he just came back and said, deny, 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 wouldn't admit anything. And that was how he went through his whole trial. So even when they went through and said, we're going to have expert witnesses, he would write, nope, deny, deny, deny. And I think there was one that was like, your name is Donald Trump. And he was like, nope, denied. It can get to be a lot. It can be a lot. Oh my gosh. Oh, really? Oh my gosh. Oh, that's so fun, Jennifer. We love that, right? That's one of your duties as the kid. All right, number 14, answering the allegations, paragraph 14 of the complaint, admits the allegation. Miss Nathan sent a communication again. So he is corroborating these texts, and that's important, right? Because if we're going to use those texts at trial, we need to make sure that they are authenticated. That's one of the requirements under the rules of evidence. And he's essentially authenticating it in his answer by saying, yeah, I agree that that is accurate, but we'll deny the rest of it. Here again, defendant's admitting the communication was accurate, but is denying how it was presented. Next, answering the allegations in paragraph 16. And then we're back to what he originally was saying, which was that he lacks the knowledge. So let's take a peek real quick and see what paragraph 17 or 16 says here. Miss Abel responded that she had just spoken to Melissa about this, about what we discussed last night for Social and Digital. Ms. Abel added, focus on Reddit, TikTok, IG, with reassurance that Miss Lively would be destroyed and buried. Wayfair and Mr. Baldoni directed Miss Nathan and her team to actively engage in their retaliatory social manipulation campaign. So we're going to need that retaliatory piece in order for her to prove her lawsuit. And over here, he's saying, well, I don't have enough information to, agree with this or disagree with this. So we've got some pretty damaging quotes in here. This would, of course, all be hearsay. We'd have to get this in through an admission exception. So we do have an exception to this hearsay rule. So it would allow that to come in. But he's saying he doesn't have knowledge of this conversation. He doesn't know anything about it and can't admit or deny it at this point. And that's a pretty significant one as well. So number 17, answering the allegations, paragraph 17 of the complaint, defendant denies the allegations. So this is typical here. We're kind of just doing the whole circuit, everyone, of what a civil case goes through. So this is typically what you're going to see in an answer more often than not. And some courts are okay with that. Other courts are like, look, the rule says you need to give me a description. And if you're not going to give me a description, I'm going to tell you go back and do a better job. But some places are like, well, whatever, let's just keep moving on. So it's hard to know what's what. All right, so we've got, again, we're going through his answer. Let me just flip here. Answering the allegations, paragraph 18. So we've got defendant denying that for paragraph 18. Number 19, admitting allegations that Tag sent communications. So we've got another one where he's saying the text is correct, but the characterization is incorrect. So we've got an admission and a denial here. Answering allegations in paragraph 20, defendant admits the allegation that Ms. Nathan sent the communication. Again, so we've got another text, which is actually really great. I think this is very interesting when you're putting your evidence into your complaint and then defendant is accepting or denying it. admitting or denying it, then that takes away a lot of the pretrial garbaggio that you have to go through and getting everything ready. Because they can just go through and say, you've already admitted this. So, we're not going to have a motion in limine over this issue. Next, here, answering as again, admitting allegations. So we've got another text involved, but the context isn't right. Here we go. Defendant admits allegation because of the text, but is refusing that it's a proper characterization of that. Next, another one again, where we've got another text. So these are just over and over and over again. We're cutting and pasting these here without a lot of detail, which worries me because we're only on page 6 of 47. Everybody, no, what's gonna happen? I don't know. So let's move this one forward here. So with number 35, we're actually into some of the factual background. So when he is saying, well, the context is incorrect, now he's getting in again to the fact pattern that she has presented. So number 35 here, allegations require no response because they merely state a legal conclusion. All right, so now we're going to get into some more interesting answers here. This is more of the legal. I was going to ask if that was what. Yeah, exactly, Jennifer. It is. It really is. So this, I think, is another great response if you're a defendant, because you're saying here they require no response because they're a legal conclusion. Well, let's take a look. Let's take a look here at paragraph 35. So here is paragraph 35. And it states, on the day of shooting the scene in which Miss Lively's character gives birth, Mr. Baldoni and Mr. Heath suddenly pressured Miss Lively to simulate full nudity despite no mention of nudity for this scene in the script, her contract, or in the previous creative discussions. Mr. Baldoni insisted to Miss Lively that women give birth naked and that his wife had ripped her clothes off during labor. He claimed that it was not normal for women to remain in their hospital gowns while giving birth. I think that's so great that he knows that as a man who has given birth. Good for you, sir. Miss Lively disagreed, but felt forced into a compromise that she would be naked from below the chest down. And then down here, we've got footnote 8. And it states, generally, nudity below the waist in film utilizes a small piece of nude fabric glued around the female actor's genitals to provide some minimal privacy without disturbing the shot, because the fabric is not able to have visible straps from the profile camera angles. So she is stating this is what happened, and he's stating that no response is required because it's just a legal conclusion. To the extent that any allegations in paragraph 35 require a response, the defendant's denying that. So again, I'm not sure this is a legal conclusion here. She's setting out bad behavior. So let's kind of break it down. So she's saying that he insisted that she do this in a particular way, right? So this is his behavior. This is the act he's doing. And he's claiming in his answer, though, that it's just, a legal conclusion, which I'm not sure why it would be a legal conclusion, maybe a factual conclusion. So I don't know about that. So there we go. Number 35, answering allegations in the complaint require no response because they merely state a legal conclusion again. So again, number 36, I'll just hit the highlight here, everyone. When the birth scene was filmed, the set was chaotic, crowded, and utterly lacking in standard industry protections for filming nude scenes, such as choreographing the scene with an intimacy coordinator, having a signed nudity writer, or simply turning off the monitors. So the scene was not broadcast to all crew and set and their personal phones and iPads. So let's just stop right here at this first sentence and take a look. He's saying here that the allegations require no response because they merely state a legal conclusion. So she's saying here, this is an allegation. She's saying what happened on the set. She's describing that and stating, wow, we didn't have what we needed. Also, they failed to close the set. So we've got actions here, of things that were being done. And so by saying, you know, they don't require any response, it's like, well, are you admitting then that the set was chaotic, that there were problems with you not closing the set at the time? Are you admitting that? So I would say there's, this could have been fleshed out a bit better. Although, you know, what are you going to do? So that's 36. Answering allegations here. Allegations require no response. We've got another one. So let's take a look at 37. It says, to add insult to injury, Mr. Heath approached Miss Lively, again, something like this isn't really needed, but whatever, and her assistant on set and started playing a video of a fully nude woman with her legs spread apart. Miss Lively thought he was showing her pornography and stopped him. Mr. Heath explained that the video was his wife giving birth. Wow, like you should open with that. You should say, I've got a video of my wife giving birth, not just like start with the video, man. Miss Lively was alarmed, asked Mr. Heath if his wife knew he was sharing the video, to which he replied, she isn't weird about this stuff, as if Miss Lively was weird for not welcoming it. Miss Lively and her assistant, which of course we love because we've got a witness here, right? Excused themselves, stunned that Mr. Heath had shown them a nude video. I too am stunned at just hearing about it. You think it was dealing with the contract of the movie? Well, yeah, I think, and there's also some basic minimal requirements just in this field that you need to have in place. So with this one, he's saying they don't require any response because they are stating, again, a legal conclusion. To the extent that it was, he's saying, I'm going to deny it. So he's not saying this didn't happen. And remember, too, in this group of defendants answering here, you know, Mr. Heath could put that out there and say, hey, she claimed it wasn't in the script. The legal conclusion is that she claimed it wasn't in the script. Are you talking about, let's talk about it. Let's talk about it. Are you talking about the video piece that he showed his wife? Is that the one that you're talking about? That it wasn't in the script? Because I don't think this has anything to do with a script, right? To show a video of someone giving birth. Is that the paragraph? You'll have to help me out here because I'm not sure. We are on paragraph 37. The paragraph 36 over here is that the set was chaotic, and that's not really in the script. The nude scene on the previous item. All right, so, okay. Yeah, let's talk about it. So we've got the birth scene here. What she's saying, the set was crowded, utterly lacking industry protections for filming the nude scene, right? Choreography, the scene with intimacy coordinator, having assigned, you know, these are the things that should have been in place. Mr. Heath and Baldoni failed to close the set, allowing non-essential crew to pass through while Miss Lively was mostly nude, with her legs spread wide in stirrups and only a small piece of fabric covering her genitals. Among the non-essential persons present that day was Wayfair co-chairman Mr. Sarowitz, who flew in for one of his few set visits. Miss Lively was not provided with anything to cover herself with between takes until after she made multiple requests. Miss Lively became even more alarmed when Mr. Baldoni introduced his best friend to play the role of the OBGYN, when ordinarily a small role of this nature would be filmed by a local actor. Miss Lively felt that the selection of Mr. Baldoni's friend for this intimate role, in which the actor's face and hands were in close proximity to her nearly nude genitals for a birth scene, was invasive and humiliating. So I'm not sure what you mean then on the naked part. Okay, so she's saying the naked part wasn't in the script? Request for her to be nude in the scene. Okay, right. So here, let's back up then. On the day of the shooting, the scene, her character gives birth. Mr. Baldoni and Mr. Heath suddenly pressured Miss Lively to simulate full nudity, despite no mention of nudity for this scene in the script. Is that what you're talking about? So in the script, it didn't say you're going to be nude, right? Okay, do we get it? She initially said there was no nudity in that scene. So, let's see. I I don't see it. I mean, again, is that number 34? Let's back up the truck. Let's talk about it because we've got some serious allegations going on in this case. So if we're just looking here, she's stating, that's the only thing I think he could be saying, the legal conclusion to, okay. But she's saying here, there's no mention of nudity for this scene in the script. Now, what are the requirements when you are signing on to something like this? You've read through the script, so you're going to have some idea of when there's going to be nudity, when there's not. And then you put that into your special nudity contract here. And so I think she was just adding a point saying, it wasn't in there. So we had to compromise. And she had felt forced into this compromise in the moment. Now, I'm sure these kinds of decisions get made all the time, right? Like, oh, well, that wasn't in the script. And then the person's like, well, I think we kind of need it. I think it helps move the story forward. And so then there's this kind of compromise situation. That's the only thing I think. Right. Okay. So I'm not sure, I'm not sure what the problem is here. He was claiming it was a legal claim because she wanted it in the script. So when he comes in and is saying legal conclusion, he's saying that there's really no question of issue. So we're not talking about, he's saying this was a wrongdoing. He's just saying, you didn't open the door for anyone to say otherwise. Actual legal conclusion is, well, let's talk about it. Let me pull up Black's Law. Here we go. Legal conclusion. Conclusion. Here we go. A legal conclusion is a statement that applies the law to the facts of the case to reach a decision. It can also be called a conclusion of law or an allegation of law. Yeah, so that's why I'm like, what are you talking about, man? How is a legal conclusion reached? Well, let's move forward here. I'm going to move past that. We'll go into a statement that expresses a duty or result without including the facts or the support. Right. So, and that's what he's saying here. All right. It's just a legal conclusion. And it looks like they're going to, he's putting that in there in order to get around the negligence piece. So that's probably not making any sense to anybody. So hold on here, everybody. Legal conclusions used. It's distinctly unhelpful and misleading. Well, that's true. A conclusion of law determines what laws and how the laws apply to a particular case. These decisions often determine the outcome of the case. I don't know about all that, but hold on here. Let me see if I can get a better set of descriptions. Here we go. Facts. Okay, so complaints conclusions are seen differently from allegations of facts. Facts, but not conclusions, are assumed true for the purposes of a motion to dismiss. The court did little to help judges or lawyers understand this elusive distinction, and indeed obscured the distinction with its language. The court said it was distinguishing legal conclusions from factual allegations. The application, in this case I'm reading about here, however, shows the relevant distinction is not between law and fact, but rather between different types of factual assertions. Okay. All right. So did everybody get that? They should have attached all the script and contracts. Well, and that will come out. Absolutely. That's a big piece. The complaint here is already so much more detailed than, your typical complaint. And then we do have some exhibits that were attached, but I'm not sure. I'm trying to figure out with this question. Yeah, that's for the trial. I'm trying to figure out though, with your question here, like why does it matter if it was in the script? Let me just ask that. Why does it matter if her being nude or not being nude in the giving birth scene is in the script? So let's kind of go down. Trying to say the script contract piece is subject to interpretation. They could have just said that. Well, yeah, I'm not sure because that's one of her claims is that it wasn't scripted. But I don't understand what you mean. Like one of her claims, you know, like should have been in the contract. Okay, so should have been in the contract. Right. So she's saying there was a breach of contract because the nude scene wasn't written in the script. Is that what we're saying here? First, it's because he was calling it a legal conclusion. Right, right, right. So, right, we've got some semantics issue going on here. Right. So, okay. So she's saying we have a breach of contract because it didn't say nudity in the script. So we're talking. Right, right. So we don't have the contract that she had here, but there's always, you know, if something is artistically changing, there's going to be something in there that allows for that. I mean, there's all kinds of stuff that changes. When she read the script and agreed to the movie, it was based on no nudity. Okay, well, I would need to see that. Yeah, that would that'd be key. If she said she wasn't going to do any nudity at all, but what when we went through what she's been saying here is that she had a nudity contract or this nudity writer, and she was saying it wasn't being respected. So we actually have another nudity contract. So adding nudity would change the contract. Very interesting. Okay, let me write that down because I don't have that here. And what she was saying either. He's basically trying to talk her into doing. Well, right, right. I got that. I got that vibe. But that's that's something that happens a lot. You get kind of pressured into doing something you don't want to do. But I'm not sure that that is going to rise to the level of a breach of contract. So again, we're trying to figure out here what's going on. The sexual harassment might be the piece of it where she's saying, you guys forced me to do this lower body nude scene and I didn't want to do it, but you had some other kind of intent involved. So perhaps the script and subsequent sign off on it becomes part of the contract. Well, we've got multiple pieces to the contract, and within the contract, it's going to say, there may be changes. That's pretty much a standard issue. Like at some point, the script may need to be changed in order to accommodate whatever, artistic whatever, with the added actions of harassment. Right. Okay. So I think that's an interesting question to ask, right? So was that what led to the sexual harassment? Now, I'm not really sure because if we break this down, we've got two pieces, right? We have the nudity piece that we're talking about, but then we also have the guy friend that's putting his face down in the business. You know what I'm saying? So was his face in the business a sexual harassment or was it the nudity? And that's one thing that we would look at here in her complaint. So let me just see if we've got it in there. Right, right, right. I got you now. All right, we're cruising, everybody. We're cruising. We're cruising down the law highway here. I'm sorry, nobody deserved that, but it's the tang. I'll just say it was the tang. All right, hold on. Let me see if I can pull this up in here. They wanted to humiliate her, right? And that's going to be difficult to prove, but definitely would be a piece to the that would be a piece of the intentional infliction of emotional distress. Yeah, so we've got other things. Now, keep in mind, I have not read on a live this whole contract, or not contract, but the whole complaint because it's enormous. So hold on, everybody. I'm just peeking in here to see if they specified that. Let's see. Yeah, I don't see it clearly in there either. This is some good questions. Again, the relevant piece of it. Don't you have work to do? I'm doing my work, Steve. What about you? Do you have work to do? Can every act together not be part of the harassment claim? Do they have separate acts? So that's a great question too. And I'm not sure how she's broken it down. Again, it's not clear in her complaint. She's done just like 10 things that she felt were violations, and then she set out her facts for it, and then has put together some exhibits. If we look at the last page of, or the last couple of pages here, again, we're just setting out fact patterns. She's not applying any of those fact patterns to the exact count. Like, for example, the emotional impact on Miss Lively has been extreme, not only affecting her, but her family, including her husband and 4 children. There are days when she struggled to get out of bed, and she frequently chooses not to venture outside in public. While she has fought to maintain her personal life and business interests, behind closed doors, she suffered from grief, fear, trauma, and extreme anxiety. She's also been experiencing repeated and painful physical symptoms as a result of this experience. Mr. Reynolds, too, has been affected mentally, physically, and professionally by his wife and children's pain. Worst of all, however, has been the impact on their young children, who've been traumatized and emotionally uprooted in ways that have substantially impacted their well-being. So this paragraph, right, number 202, is explaining the harm that was done. This is part of what we need for a remedy when we're talking about the intentional tort, right? So intentional infliction of emotional distress, we need to have some kind of a showing for that. And so she's putting the showing in here, but we don't have like a label that she's saying, well, this is what's going to the intentional distress, and this one's going to the harassment. It's just not set out that way. We've just got like rapid fire facts in here that she's putting, her facts that she's putting in here, and then it's like you can kind of pick and choose from the buffet of which count you want to add it to. Yeah, it certainly isn't, it's not, it certainly isn't an easy way to put all of the information together, doing it that way, but absolutely appreciate it. Oh, thanks, Casey. Thanks. Right. So I think here, every act together not be part of the harassment. Yeah, I think, well, that's one of the pieces to everyone. When we go through the damages, she's asking for the damages. She's saying these 10 things occurred, and she's basically put out like, here's 200 examples of it, and you can pull out what you want in order to meet the obligations. But also her attorneys will set this out in clear pieces when they start putting the trial together. Does it all fall under one claim of harassment? So that's a good question too, because she's saying here sexual harassment, but she doesn't have under here a specifying the exact acts that were involved. So she's saying this harm was done, and here's 200 facts, and within those 200 facts, you're going to find this. This reminds me a little bit, everyone, maybe if we could go over to Georgia, to the RICO case, right? So the RICO case set out, we had RICO, so that was the charge. And then underneath that, we had 162 acts, right? So you could go in there and all you needed was 2 or more acts to hit the RICO charge. So rather than going through and saying, well, number 102 and number 98 are RICO, what they're doing is they're saying, here are all the facts, and within there, if you can find 1 or 2 here for harassment, or just 1 technically, then there you go. See what I'm saying? Not in the complaint, Jennifer. Wow, what a great question. No, you don't need to clarify that in the complaint necessarily here, because the facts that she's putting out there, he seems to be just going line by line and stating like, well, this fact is not applicable, this fact is not applicable. Rather than, going, well, all of the sexual harassment claims or all of the retaliation claims, it's not specified. Yeah, it's not specified. So she's kind of doing like a potpourri of facts going on, and with the acknowledgement that something is going to catch, something is going to be that violation of that piece of the tort law. Mm-hmm. Does that make sense, everybody? Am I making sense over here? I don't know. Atticus is snoring, and sometimes that makes me nervous. This is a great question. Yeah, and I think it's worth asking. Okay, good. Good. So let's dive back in again. We still have we still have all of his defenses. He's got defenses that he's going to be putting in there. He's still answering all of her facts, and then he's setting out all of his additional defenses, the relief that he's requesting as well. So we've still got quite a bit here to go through. Okay, thank you, everybody. So let's dive in. I think we need to probably kick it up a notch. So we'll just go through here a little bit quicker. So here we've got requires no response again because of the legal conclusion. So there's this question between a factual assertion, so she's saying this is what happened, and a legal conclusion. So there's like this question about it, and I'm wondering if that has to do specifically because they're in California. Maybe a California thing, but what they're just saying here is that it doesn't require any kind of response because it's just a statement rather than an issue. So I would say, because of the different ways that they're answering and making the claims. Exactly. And it's a bit confusing, right? Because it's like, spin the wheel. Which one works? Wheel of Fortune style. Like, let's spin it around. Here's a fact. And which one of these offenses does this fact fall into? Which is opposite of how we do it in the criminal world. In the criminal world, we say, here's a count. Here's what the law says, here's what you did, and that's how you violated it. But we're in a different world here. In the civil world, we don't have, this is how you violated this particular statute. And it's just not always necessary. Snore loud because of sinus issues. That could be. I think it's because he's just getting too chubby. At least that's what I say about my own snoring. It's because I'm getting too chubby. That's funny. I thought everything was like that. No, not all the time. And different states and different systems do it differently. Like I tell you right now, this kind of complaint in my state with these kinds of answers would annoy my judge. Like I could do it, but my judge would be like, that's not what we do here. Like, do your local work, man. Right. I wouldn't use this as a template unless you're in California. So that's kind of how this one goes about. So here's another one. No response again because we've got this legal conclusion. Answering allegations here. Defendant admits the allegation that Miss Nathan did business in Brooklyn, New York during the allegedly relevant period, but denies that she engaged in efforts to bury the plaintiff. All right, so we have an admit and we have a deny here. Right. So the next one we should be able to get through a little bit quicker. So we've got deny. So this is more of what it looks like in my jurisdiction. We wouldn't be able to get away with like 500 things in one suit. They would get so mad about it. But this is what you do. Okay, so we got deny, admits. Ooh, this is good. Here we go. Defendant admits allegations in paragraph 26. So we've got a full admission. Let's take a look and see what's in paragraph 26 here, everyone, so we can see what he's admitting to. Oh, he's admitting to one of my red flags. Here we go. So Mr. Baldoni launched Wayfair Studios along with Mr. Sarowitz in 2020. Mr. Heath serves as Wayfair's chief executive officer. Mr. Sarowitz is a leading financier of Wayfair, and Mr. Heath, and Mr. Baldoni are all close personal friends. See, this is like, why would this could be seen as a legal conclusion as well. So I'm not sure about all that. Under the Wayfair banner, Mr. Baldoni and Mr. Heath have many platforms, including the Main Enough podcast, which they co-host. Mr. Baldoni and Mr. Heath have positioned Wayfair as a male feminist platform that explores gender roles, dismantles toxic masculinity, and creates a safer and judgment-free society for women. That's all right. So apparently that he's admitting that that's all true. So that's okay if he wants to do that. I would say none of that would be harmful for him. So here we go, lacks knowledge. We've been down that road. Also 28 lacks knowledge, 29 lacks knowledge, 30 lacks knowledge, 31 lacks knowledge. So this could be because of other people that were involved and so forth. Next here, admits the allegations. So we've got paragraph 32. Let's take a peek at that one. 32, because these are the admissions, right? So number 32, on another occasion, Mr. Baldoni and Miss Lively were filming a slow dance scene for a montage. Now hold on here. He is saying paragraph 32 admits. So he's admitting everything that is in this paragraph, all right? We're filming a slow dance scene for a montage in which no sound was recorded. Mr. Baldoni chose to let the camera roll and have them perform the scene, but did not act in character as Riley. Instead, he spoke to Miss Lively out of character as himself. At one point, he leaned forward and slowly dragged his lips from her ear and down her neck as he said, "It smells so good." This is just gross, everyone. I don't think we acknowledge how hard it's got to be for these actors, men and women and whomever. It's got to be rough for them to do these kinds of scenes, I would imagine. None of this was remotely in character or based on any dialogue in the script. So we've got another thing in the script moment. And nothing needed to be said because, again, there was no sound. No, this could be an opinion here. Mr. Baldoni was caressing Miss Lively with his mouth in a way that had nothing to do with their roles. I think that could be questioned. When Miss Lively later objected to this behavior, Mr. Baldoni's response was, "I'm not even attracted to you." This right here, this statement that he's admitting right here, this is sexual harassment. That statement is sexual harassment. So if none of the rest, if it's like, well, that's your opinion, this right here would be a ding to sexual harassment. Think about that. I know, right? So, yeah, I mean, I it's part of the job. I guess you acknowledge and move forward, but on the other hand, I think it's okay to take a moment and say like, "Ooh, that's rough." So he is admitting that he said this sentence. He just said here, defendant admits such allegations. So defendant admits, "I'm not even attracted to you," as the statement. If you'll remember with Mr. Trump, of course, that statement was used to prove his defamation. Right. What 47 exactly will be? Oh my gosh, great minds think alike. That's just what I was going to say. Exactly. Like, oh my gosh, everybody. What's happening? Our world is just crazy land. All right. So I think this is a good one here. As we go through it, I think you got tangled in that one. Answering the allegations in paragraph 33, defendant admits the allegations. Oh, we've got another admission here. All right, let's take a look. What have we got next? 33. Here's 33. After Lively signed onto the movie based on a draft of the script, Mr. Baldoni, without Miss Lively's knowledge or consent, personally added graphic content, including a scene in which Miss Lively was to orgasm on camera. All right, so he's admitting this as well. And again, without their contracts, we're not going to know the extent of, her nudity clause, whatever it is that she can do or can't do. And it's looking like he's added a whole bunch of stuff. I'm not sure adding it is going to be a big enough issue, except if you pull the intent element in, right? So I think that would be, what did you highlight in 32? Right, this is a direct quote that she's using here. So I'm not even attracted to you. That's the highlight. Here we're just into another subcategory in B. So kind of moving on from there. All right, so that's not great, and he's admitting it. Here, defendant lacks knowledge for number 34. Got it. And then we'll just, I did the pages backwards, but I don't think it's going to matter. So let's go through these here. Legal conclusion again. Lacks knowledge. All of these are all lacking knowledge. All right, so that takes us to paragraph 51. Here again, we have knowledge. lacking. So he's just saying, I don't have enough like he could get up and say, I don't remember that, or I don't remember that, or I don't remember that. That's kind of what that lacking knowledge means, like, Ronald Reagan style here. Here we go, more knowledge. Wow, we've got like 3 pages of I don't remember. So, okay. And then again, I don't even need to circle all these. Knowledge. I don't have any knowledge. I don't remember anything here. And then all of these are knowledge as well. So let's get flipping. I'm interested to see what he's going to be using for his defenses. Again, all of these are I don't remember. All of these I don't remember. And okay, so then until we get to this one here. He wasn't taking notes. Well, that's a good question, everybody. When it comes to documenting, I think that this is a really good point that people make, and that we tell people all the time. Is like, well, keep track of it. And sometimes you don't have to write everything down or have it perfectly documented, but sometimes even just having take a picture with your camera of the calendar of the date and the time. And then just title it whatever was said. If you want to put more information in, fine, but at least it gives some credibility to documenting it, and it's easy enough to do on the fly. Answering the allegations here, the defendant admits the allegation that Tag sent a communication containing the text set forth in paragraph, but denies the rest. We've got an admit and deny here. Right. Who was it that said I do not recall? That Ronald Reagan. Yeah, so it's the, all the defendants are saying, look, I just don't remember any of this. Next, lack of knowledge here. And then we have admits the allegation about a communication again, but denies the rest. We've got another, whatever was said is okay, but the rest isn't. Answering allegations, admits the allegation about communication again, but denies the rest. So we've got more of that going on. And more here, admits that the Hollywood Reporter published an article containing the text set forth in the paragraph. All right, so that's an admission, but denies the rest here. And then we've got another, denies the allegations, lacks knowledge here, admits to the text, engaged directly with media sources on behalf of Mr. Baldoni and Wayfair regarding Mr. Baldoni and the film. Okay, denies all the remaining allegations. So he is admitting that he hired that woman to do the job. I don't know what they're called. Are they still called spin doctors, everybody? Is that right, or am I just losing my mind? Answering allegations here, admits the allegations. So let's look at paragraph 129. We're making some room here. Let's see. 129. He's admitting. So really, really funny. I'm a spin doctor. All right. I don't even know where that came from. Probably high school homecoming. What am I doing? I don't know. All right, here, I'm finding it. We're going to get there. 129, he's admitting. All right, so this is an admission. Let's see what he's admitting to in her complaint. On August 9th of 2024, Ms. Nathan indicated to Ms. Abel that she was on the phone with her sister, Sarah Nathan, a journalist at New York Post and contributor at Page 6, and remarked that Mr. Baldoni's religion should be taken out from media coverage. She went on to state, and mostly the misogynistic. All right. So he's admitting to that. I don't think that helps or hurts the case. But all right. Again, we've got some more text here, but is denying the characterization. Admits, sent a communication. Again, another text here, characterized. Admits allegation that the communication contained the check. Okay, so he's still affirming the information in the text as being true. All right, so he's backing it up. So again, the most important thing, in my opinion, is that when all of these texts and all of this information is used at trial, he can't come in and say, that is all lies because he's already admitted to it in a legal document. He's already said these texts are correct. The context might not be, but the texts are correct. And that's huge. Again, makes the case a lot easier to move forward that way. All right, deny, admits here, communication containing the text. Lacks knowledge here. We've got more texts. We've got text again here and more text. There we go. I really am interested to see what his defenses are going to be. We're getting there, everybody. We're getting to the defenses. Are we though? Let me see. I'm going to just glance and see if we have anything interesting on this page. Allegations, text. Nope. We don't have any admissions or anything. Here we go. Text. Oh, thank you. Oh, that's so sweet. I appreciate that upgrade. I really do. Answering here, admits the allegation about, okay, so again, nothing that interesting here. We're skimming through everybody. Allegations. We've got all these texts again that we're talking about, and a lack of knowledge, and so on. Let's see here. More, and a lack of knowledge. Again, I'm skimming through so we can get to the defenses, because I think that'll be very interesting. All right, here we go. Defendant admits that Mr. Baldoni sent a communication linking to a TikTok video, and a member of Miss Nathan's team sent a communication containing the text set forth in the paragraph. So again, he's saying the text that Miss Lively put in there is correct. Defendant denies all the remaining allegations in the paragraph and specifically denies that the communication and its context are characterized accurately in the complaint. So this one would definitely be... I think this one would definitely be one they would be contesting in front of the jury, because there's a lot of ways that it could go. Here we go. We've got another one. Admits allegations, sent communications, and that the text was correct. Context might not be. All right. So we've got deny, knowledge. Here. All right. Here's another one. Answering the allegations in paragraph 177 of the complaint. Defendant admits that an article bearing the headline set forth in the paragraph was published by page 6. Defendant denies all the remaining allegations. So he's admitting to the publication there. An article, again, here's another text. Lacks knowledge, admits here. So is admitting that the allegation shared the aforementioned article. All right, so we've got that as well. Admits the allegations that Miss Nathan sent communications containing the text, right? So we've still got that. We've got another text here. Lacks knowledge, denies. So that's just a straight up deny. Let's look at that one, because he's not just straight up denying anything really that exciting. So let's take a look and see what it is that he's like, that's just not it at all. You can get some idea where he's coming from. 184. Now, let me see, are we flipped? Got page 54, page 55. Oops, sorry everybody. There we go. And, can we not? Okay, 55. So we're at 185 here. Let me just double check this again. So we've got 81, 82, 83. And then we have BCD of 83, and that's page 55. So then we turn it 56, and we have 184 here. All right, we're on 80, which one? We're 85, so 185. While there was considerable online coverage of the film and Miss Lively leading up to the film's nationwide release in U.S. theaters on August 9th, this to me looks like it would be that legal conclusion bit that they're talking about, but whatever. The coverage was mostly neutral. Some online discussions referenced an apparent feud between cast members, but they included a smaller percentage of negative and positive. All right, so he did admit to that. It's not very exciting. Here we go, lacking knowledge. So again, I'm just trying to see here, everyone, if he's got an admission that might come back and haunt him. Oh my gosh. And then again, this is what a typical answer would look like. Where in this one, he's saying he doesn't have any knowledge. I don't know what you're talking about here. All right, this is a good one also, emails tonight. Oh, thanks. I appreciate that. So, defendant lacks knowledge or information sufficient to form a belief, right? That's what all of these have been. Like, I don't remember, I don't know what's going on. But here, defendant denies all of the remaining allegations. Oh, hold on here. Just a minute. Information, state of mind. So we've got, again, state of mind is one of our most common objections when people are testifying. They're saying, well, did that person seem angry? And then you say objection because you're asking them to speak to the state of mind of someone else. So we got to kind of keep that in mind, so to speak. Again, none of these, everyone, have any particular extra piece. They're just deny, deny, deny. All right, we're skipping through, everybody. We're skipping through. I don't even see anything in here that is, all right. No, we're skipping through his, this is why attorneys get paid by the hour right here, man. This is a lot of work. Putting this together, the person that drafted this, probably a paralegal in the office. This is a lot of work. It's a lot, because you still have to make sure that each one of these goes to each paragraph, even if it is the same words over and over and over again. All right, are we getting to the defenses? There we go. We're almost there. Yay! Here we go. I want to see what this guy is gonna claim. Okay, here we go. Whew, everybody. Wow, I was sweating on that one. That took a lot. Here we go. Let's talk about defenses then. Let's see what he's got to say about that. That was a lot of work. My goodness. A lot of copy and paste. Absolutely. All right. So here we go. We're bringing the cow back out, everybody. All right. More cowbell. So affirmative and other defenses. All of this, again, is his denials of the complaint. Next thing is, this was a huge issue with Mr. Trump, was that he didn't plead his defenses out before trial. And, Jack Smith was like, dude, we've got rules, procedural rules. And so here they've already put their affirmative defenses in with the answer. So, boom, you've got notice way ahead of time, which is great. So affirmative and other defenses. By alleging the following affirmative and other defenses, defendants not in any way agreeing or conceding that it has the burden of proof of persuasion on any of these issues as a separate and distinct defenses to plaintiff's complaint and each purported cause of action contained therein. Defendant alleges as follows. So we have to remember too, who's got the burden of proof, right? So she has the burden of proof when it comes to her civil complaint because she's the one that filed it. She has to show upon a preponderance of the evidence that him and his company are liable, have done some harm. When you put an affirmative defense into the mix, the person pleading the affirmative defense has to come in and that burden shifts to them to prove that it actually happened. So here's one. The complaint, or first defense, the complaint in each claim therein fails to state facts sufficient to constitute any claim for relief against the defendant. And that's pretty typical. I would say that this is probably the weakest defense there because our complaints just aren't conducive to putting that kind of information in there. Second defense, in each claim alleged is barred as plaintiff lacks standing to sue. What? Ooh, that's a big one. So he's saying she doesn't have standing, so she doesn't have the right to actually sue. That's interesting. So, when a lot of people get frustrated with standing, like Mr. Trump gets really frustrated with standing. He's like, they wouldn't even hear our election case. They wouldn't even hear it. They said don't have standing, blah, blah, blah. That's because it's really important. Like, courts don't take every single case. You do have to have standing. That's kind of important. And it just means that the plaintiff is clearly connected to what's going on there. So if you have an issue that is not ripe yet, that means, this is something that's going to happen in the future, but we can't pin it down, then we'll say it's not ripe. Or it's already happened and nothing can be fixed, then we would say it's moot. So these two terms are directly in line with standing. So you'll see all three of these terms put together. Standing can get pretty complicated, but it's a key piece. Particularly in our criminal cases, standing becomes an issue when they're working with Article 3 courts, which we know mean federal courts, right? So that's another issue. Third defense here, each claim alleged therein is barred as plaintiff has waived her claims. Ooh, that's interesting. So they're saying she's waived any claims to bring a lawsuit. I don't know how that is working out. It seems like they could add a little bit more information here, but whatever. That's going to be very interesting to see how that's argued. Fourth defense here, claim alleged herein is barred as plaintiff is stopped from asserting her claims. So I don't know why we've got to stop. Typically, when we say that something's stopped, it means that they have already taken care of it in another place. So let me just see here. From asserting. Just double check on that language. It's one from asserting a claim or right that contradicts what one has said or done before or what has been legally established as true. Interesting. So yeah, so he's basically saying like, well, you agreed, or there was some kind of an agreement that she was consenting. So I would say this is going to be in most sexual harassment cases and a lot of situations, we consent is the number one defense. So I think this is kind of what he's going for with this estoppel. Like, hey, we were joking around and, I didn't think it was any big problem. Arbitration. Well, I do know mediation's involved. That is something that's on the docket. They do need to go into mediation or I don't have any results yet. But exactly, that's a really good point. Is if you bring it up and you agree to it and you've got some kind of an agreement in place, then you can't come back. Fifth defense here, plaintiff acted and continues to act with unclean hands. I don't know, that must be a California thing, but I would say here, what they're trying to say is that she's responsible for 51%, right? So she's actually an active participator in the harm that was involved, right? So if you are part of the harm, then you're not going to be able to come out on top of a civil case, if that makes sense to everybody. Right? So let me give you an example. If you've got a toaster, right, and for some reason you didn't read the label, and so it's plugged in and you put your hand in it and you get a burn, you can't go and say, well, I'm suing the toaster people because I burned my hand. They're going to say, you assumed the risk when you put your hand in a toaster, or more likely they're going to say you didn't read the manual where it said don't put your hand in the toaster. That's kind of what we're talking about here. It's like you're partially responsible for the harm that was done. And so because of that, we have a lower level of harm. Right. That's always fascinating. So, and I always tell people this as well. Don't MacGyver your stuff, everyone. If you have a vacuum, don't just like zoop it up with gasoline or whatever to make it work better, because once you start tinkering with an object, it's less likely that you're going to be successful in a lawsuit if that item explodes. All right, that's just telling you, that's just how it is in the legal world. So, take that how you will. Sixth defense. Sorry, everybody, I tell you, products liability, that's where the laughs are. That's where the good stuff is right there. All right, plaintiff has not been damaged in any way. So this again is another piece. If we've got for the intentional tort as well as for negligence, if they can't show any actual damage, then they're not going to be able to remedy it. And if a court can't remedy your problem, then your case doesn't have what it needs to go forward. So this is a pretty typical thing to say. It's like, oh, well, you haven't really been damaged. And so this also explains why she probably put that language in stating that, she can't get out of bed and her family's so stressed out and blah, blah, blah. Because, and rightfully so, because they're showing that is the damage. That's the damage that she's sustaining, is all of these different things that are happening because of the stress of the situation. Seventh defense, barred whole or in part by the First Amendment of the Constitution of the United States. What the actual, what? I'm sorry. What? Okay. What? Oh my goodness. The complaint and each claim alleged therein is barred in whole or in part by the First Amendment of the Constitution of the United States of America. What? That's madness. Is it because I'm drinking Tang, everybody? Hold on here. That's madness. So, trying to say he's got a First Amendment right to be like, hey, what's going on? Like, no, it's not how the First Amendment works. One party has to be the government. There has to be some kind of forced rule in place. I just can't. Oh my gosh, stop it. Look at what Mr. Trump's done to the rest of the world, everybody. He's made everybody plead out the First Amendment. Like, are you kidding me? Oh, to get the judge cannon on that one. I'm allowed to sexually harass her because it's freedom of speech. Oh my gosh. That's bananas. I can't. His attorneys don't seem too knowledgeable. Well, you can't just give it to your clerk. You need to read it before you. You're losing points on this one, buddy. That's a point deduction. I don't even know what that means, so we'll move on from that. Oh my gosh. Yeah, so, my goodness gracious. All right, moving on. I'm going to pretend this didn't happen, but I'm taking points off. All right, the eighth defense here, each claim alleged is barred by reason of plaintiff's consent. Now, consent again. So we do have this talk again of consent because it's already been litigated one way or another. But this is the actual defense of consent, where it can't. If you agree to it, then it can't be a problem. I think, in my opinion, in this case, and because we don't have her contract and we can't read the details of her contract, we may get tangled up in consent. It could be possible. This is the number one defense in our SA cases, and it wins. It's because they win on it a lot. When we're talking about consent, we're going to talk about how, well, it's like joining a sport. If you're going to be a boxer, and you're like, oh, I got hit and I got some damage done. It's like, well, dude, that's boxing. And she's going to come in and say, wow, he was way out of line. And he's going to say, well, I'm the creative director fella, and I needed to do and say these things in order to get the proper, whatever it is, in order to put the film up, right? So depending on how her contract goes, he's going to claim, well, she didn't care. It wasn't a big deal at the time, and I needed to do that in order to produce this movie. So I think this one, I'm going to highlight it because I think, as per usual, this idea of consent or implied consent could absolutely be something to tangle her up. Can't believe they put it in right. I know. Oh my gosh, yeah. This one out of all of them so far, I think is probably the strongest defense, and the one that we're going to hear when this is like made for TV movie. Assumed consent because she didn't say no or stop it from happening. Well, it's going to be, that's a great point. The issue here is going to be what's in her contract when it comes to script changes, the environment that she's in. And I don't know, like the OSHA regulations for, movie sets and stuff, but I think the assumption that she consented wasn't necessarily because she didn't say no. It was just that when you sign on to the movie, there's a few things you understand are probably going to happen. And, the love scenes are going to be there. There could be some nudity involved, like because she's worked on so many other films before. the argument would be, if I was his attorney, the argument would be, well, she knew what was going on and he clarified it and, nothing came of it and blah, blah, blah. So I think part of it could definitely be because she didn't, go crazy when it happened because she's a professional and you keep moving forward. But the other part of it is just, this is just what happens on these kinds of sets, which is why this case is so important, because it needs to set a standard to say this isn't what just happens. This should not be just regular protocol. This is not consent. PRT after the production, she clearly, exactly right, exactly right. So we have acts that she has been harmed by. That's what she's claiming, and then before and then after. And I think that's it's a really good point, because several of the counts that she's pulling in have to do with that online campaign against her or whatever. So yeah, we're walking a line here. And if they come back after this case is done and they hold that she consented because she knew what she was getting into, that's going to be a huge hit to the entertainment industry for women. It's going to be huge. So hopefully, yikes, hopefully that particular defense isn't utilized, but we'll see. It's the strongest one so far. Here's the ninth one. The plaintiff is barred, has failed to undertake reasonable measures to mitigate the damages she claims to have incurred. Any recovery by plaintiff must be diminished to the extent that any alleged damages could have been avoided if such measures had been taken. So this one's incredibly weak also, because they do want you to mitigate your damage. So for example, if you were in an accident and somebody, well, let's say like your neighbor was mowing his lawn and decided to just, for some reason, was chasing after an animal with the lawnmower and accidentally cut your leg off. All right. So you're saying, well, you took my leg and I need to be compensated for the loss of my leg and my medical bills and so on. And so you go in and you have your medical bills, but the doctor's like, well, you need to do some rehab in order for you to be in a better place to be able to do stuff. But you refuse to do the rehab. So, everything's just all messed up. All you can do is sit in a wheelchair all day because you didn't go to rehab. Rehab is what would mitigate the damages here. And courts want you to do that. Courts want you to go and look for a job, or they want you to go into treatment. They want you to figure out a way to live your life even though you have been harmed. So if you don't do any of that, or you don't have any kind of good faith effort to mitigate your damages, then the court can reduce the amount of damages given to you. That's the long and short of my lecture on mitigating damages, everyone. Don't forget to fill out your review here. Oh my gosh. All right. So any recovery has to be diminished, right, to the extent as well. Now, her mitigation of the damages were holding the meetings, writing things out, documenting things. So she tried. She talked to them. She's got evidence of talking to the Sony person, this meeting again. So mitigating her damages is not going to be an effective defense, in my opinion, in this case, because she did work on it. 10th defense. Oh, by the way, and I have to say this too. Look, if you get run over by a lawnmower and you lose your leg, I'm not saying you have to go and like get a job or, whatever. I'm not saying you have to do that. I'm just using that as a hypothetical, okay? Let's clarify. Let's clarify that. Here's our 10th defense. We've got a plaintiff is informed and believes, and on that basis alleges, that plaintiff would be unjustly enriched if recovery were to be had on this complaint. What? Plaintiff is informed and believes, and on that basis alleges, that plaintiff would be unjustly enriched if recovery were to be had on this complaint. I don't know what this means, but I'm thinking this is going to be some kind of a reference to a discussion that she had with them. Yeah. Oh, no problem, Bruce Wayne's mother. No problem. You were able to skip through all of our answer pieces. So losing a leg with a lawnmower sounds like something from yeah, I know. I'm sorry, everybody. I used to give examples involving chihuahuas, and I had so many students that were like, what happened to the chihuahua? So I had to stop it. So I just use something else. Like, it doesn't involve a chihuahua, then I'm okay. So this 10th defense, everybody, I think is questionable. We've got some kind of communication going on that's justifying them putting this in here. 11th, plaintiff has not been damaged in any amount alleged or in any amount whatsoever and is not entitled to any general, compensatory, statutory, punitive, or other damages. This is pretty typical language also for this defense, and we kind of talked about that already. She needs to show that she was harmed and that the court can remedy that harm. Those are essential pieces, or else, you're out the door. Next, 12 here, plaintiff excused any alleged act or alleged failure act on the part of the defendant. So an excuse is just another, again, legal defense that you can use. Before we had consent, right? But this one is saying, well, I didn't have consent, but she said it was okay. So consent's kind of before, excuses after. So to have this means that there's some kind of proof that she was like, oh, don't worry about it. It's no big deal, whatever. So I think that's what they're talking about here with the excuse defense. The defendant had any alleged obligations or legal duties, and this is going to be his negligence defense, because those are two elements, which defendant hereby expressly denies defendant has appropriately, completely, and fully performed and discharged any alleged obligations and any alleged legal duties arising out of the matters alleged in the complaint. So he's saying that there's absolutely no negligence because he didn't have any duty, and that, of course, is what we plead in all of our cases. When negligence is one of them, we put that in as a defense. Well, I didn't have a duty to do that. Like, all right, then. There you go. 14th defense. Damages and injuries, if any, suffered by plaintiff were directly and proximately caused solely by the acts or omissions of the individuals or entities other than the defendant. What? This is also ridiculous. Come on, man. It was someone else. That's really sloppy. That's sloppy lawyering, everybody. I'm not afraid to say it, but look, you can't just say, somebody else did it. It wasn't me. Oh my gosh. If there was, we're saying there wasn't, but if there was, it was somebody else. Exactly, VC, exactly. I'm telling you, the legal world, everyone, is really in for, we're going to be struggling in the legal field. We're already getting called into emergency meetings by our bar associations. They're like, don't do this, don't do that. It's like, what's happening? Just blame Biden. Exactly. It's because of the laptop, everybody. It was the laptop that caused the injuries. Oh my gosh. Right. Exactly. All right, 15th defense. Here, the damages, injuries, if any, suffered by plaintiff were directly and proximately caused. So here's causation. So they're talking again about negligence here. Remember, she pled one of the harms done to her was negligence. So they're coming into causation. Remember, we talked about those 4 elements. Duty, breach, then we have to have that link between what the act was and that they caused it. So we have that causation element, and then damages. So what they're saying here is they're going off of that third piece, and they're saying the causation element's not present for negligence. And so, that's not a piece that you can use. Solely by the reckless, negligent, and wrongful conduct of individuals or entities other than the defendant again. So if there was any cause for harm, it was somebody else that did it. As a consequence thereof, plaintiff is barred from recovery here. Right. So there you have it. Why would she have negligence? Or you may need to add a few more words. I apologize. So there's been another, oh my gosh. Yeah. So was that is that Philadelphia? Oh my gosh, everybody, we can't. Oh my, no. Block it out. We blame anything broken on Mr. Nobody, and it's been useful defense since I was a kid. Oh, I know. Well, I always say it's the fairies. I'm like, oh, okay, it's the broken vase fairies. They were trying to make a home here. All right, here we go. Moving forward. I'm a little off right now as time goes on, everyone. It's the tang. Okay, I got you now. Pug's Cone, I got you. Crash in Philadelphia. Okay, yikes. Okay. Next up, we've only got a few more defenses here, everyone. The damages and injuries, if any, suffered by plaintiff were directly and proximately caused. Again, we've got negligence solely by the intentional misconduct of individuals. This is our intentional tort piece, or entities other than the defendant. So here with causation, we're dealing with this piece of negligence, but when you put in an intent level, now we're dealing with an intentional tort, which has a different set of pieces that you have to put together. Yeah, I'm still on, Kristen. I know. I'm sure everyone in the chat's like, oh my gosh, she's still talking about it. I know. We're almost done. We're almost done, everybody. We're going to make it. Fails to state facts sufficient to permit an award of punitive damages. Again, these are meant to punish. So these are like the big Giuliani ones. That may be true. The complaint in each and every cause of action alleged therein fails to state any facts supporting any claim for punitive or exemplary damages. So again, that's boilerplate. Is what does Tang have to do? You think so? Something else? No, it just gives me an extra bump. I don't know. Oh my gosh, it's not sugar free, I guess. Let me put it to you that way. The complaint in each and every cause of action alleged therein is barred in whole or in part because at all material times defendant acted in good faith. Oh, I hate this defense. And without malice based upon all the relevant facts. So this is, again, the good faith defense. It doesn't work in every state or in every situation, but if you have it in your state, it's always good. Everybody always puts it into their defenses, like, well, it was good faith. It was a good faith effort. If something happened, I didn't mean it. I've got no malicious intent. So that one goes in. All right. Plaintiff and her agents, servants and employees, servants. Do we even use that anymore? All right. And employees had failed to bring the causes of action alleged in the complaint in a timely manner and therefore barred from recovery. So this is a statute of limitations and by the equitable doctrine of laches. Again, so, we got to just watch the time when we're filing it. Defendant alleges that in the event it is found in some manner legally liable to plaintiff as a result of the events or occurrences described in the complaint, that liability will be solely based upon a derivative, vicarious, or imputed form of a liability. Well, this means he's trying to say it wasn't me. It could have been an employee. It could have been someone I worked with. It was another person, but it wasn't me that directly caused it. So he's moving that ownership down the road, not resulting from its own conduct, but instead based upon an obligation imposed upon it by the law or by the conduct of others. And as such, legal liability of defendant would be proximately caused by the acts or omissions of others. We also would call this respondit superior, is another thing that we toss out when we've got employees involved. So he's basically saying, like, I'm responsible for what my employee did, but I personally didn't do any of it. I don't know how that's going to work at all. 22nd defense. A defendant alleges in the event that it's found some manner legally liable to plaintiff as a result of the events or occurrences described, that liability will be based solely upon derivative, vicarious, or imputed form of liability, not resulting from its own conduct, but instead based upon an obligation imposed by law again. So a defendant is entitled to recover total and complete implied and or comparable indemnity from them. So he's saying if other people caused it, so if you find that there's damage, other people caused it, and I should be able to sue those other people as well. So that's that. Defendant alleges the event is found in some manner legally liable to the plaintiff as a result of the events, again, based solely upon the derivative, vicarious, or imputed form of liability, not resulting from its own conduct. Oh, look, we're coming down to the final ones, everyone. Shoo! But instead based upon the obligation imposed by law, by the conduct, legal liability of defendant would be approximately caused. So he's cleaning up the causation element for that, saying that, again, it was his employees that did it, and that causation element involving them. 24th defense, any injury or damage to plaintiff, which defendant specifically denies, was approximately caused by the negligence, recklessness, intentional conduct, or so on, by one of more of plaintiff's legal counsel, agents, or representatives. Accordingly, if any liability is found on the part of the defendant, then defendant's liability to plaintiff shall be reduced on the basis of comparative fault. Wow, that's interesting. All right, so we've got a couple different kinds of fault. We have contributory fault and comparative fault, and this is another way of kind of pushing that liability onto somebody else. So just because the harm, I was involved in the harm, doesn't mean that I harmed you more than somebody else or you harmed yourself, right? Because we're trying to go after that 51%, everyone. So 51% liable. So if he can come in and say, well, there were other people that were liable. So let's just say, you know, this person, I don't know, there was a TV guy and he's 25% liable. And then, you know, maybe I'm 25% liable here. And then someone else comes in, they're 1% liable. So he's trying to split it apart and pick up the faults or put the fault into other areas so that it's not completely his fault, which would mean, you know, if he's only found at 25%, then he would only need to pay 25% of the damages. I know we're getting into the weeds here, everybody, of civil law. Always have this many defenses. No, they do not. They don't. He's definitely covering everything. I mean, he's cutting and pasting and including things by just turning, I mean, he's putting everything in the kitchen sink is what I would say. This is what I would call a shotgun answer, which just means that he's just spraying everything. Maybe spraying's not the right word, but it's getting late. He's just including everything in here. But this is a great term to understand, know and understand here when it comes to fault in civil cases. Any injury or damage to plaintiff which defendant specifically denies was proximately caused by the negligence of the plaintiff. All right, so now he's saying it's her fault. So she is 51% liable. She did 51% of the harm to herself, and that means that he's not responsible at all for any damage, right? So it's the race to 51%. If she is 51% at fault, putting herself into the situation some way, and he's only at 49%, then he's off the hook and she gets nothing. So that's what he's claiming here. So any injury she caused to herself. Plaintiff's alleged damages are too speculative to permit recovery in this case. So again, this is another one saying you don't have an ability to find a remedy. So that's one of the key elements, and you don't have that. The complaint and each and every cause of action alleged therein is barred in whole or in part by the doctrine of in peri delicto. Oh, let's look that one up. I'm not familiar with I know in flagrante delictico, but I don't know in peri. So let's look it up. Here we go, everybody. This will be our new Latin phrase that we'll have to use all the time. Okay? In peri delicto. Here we go. Equal fault, a doctrine of contract or tort law, preventing the plaintiff from recovering damages if they were also. Okay, so this is going to be specific to contract law. We always put a K there for contract law, just so you know. The K means contract law. And this term is specific to that. So it's basically comparative fault for contract law. We're in the weeds, everybody. Bear with me here, all right? Bear with me. So equal, we're going to say equal fault here. If you have an equal fault on your breach of contract situation, then under this doctrine, you're unlikely to win in that case. Throwing stuff, right, at the wall. Exactly right, exactly. I love the weeds. No, the weeds. All right. We're getting there. We're coming. All right, we're coming down to, I see the light, all right? I see the light. And then whenever I say that, my husband's always like, don't go to the light. Don't go to the light. Step back. It's like, okay. Sorry, 28th defense. 28th defense, dang. 29, all right, 29 defenses plus additional. Dang. All right, here we go. This is a journey, everybody. We are going on a journey here. All right, the complaint and each and every cause of action alleged against defendant therein fails to allege facts sufficient to allow recovery of attorney's fees. All right, that's just additional. Oh my gosh. 29, plaintiff's claims based upon California statutes are barred because plaintiff does not allege that defendant took any wrongful actions within the state of California. I'm not sure about that. I mean, I think that's kind of, yeah, that's weak. We're weak. Reservation of additional defenses. So defendant presently has insufficient knowledge or information on which to form a belief as to whether or not it may have additional, as yet unstated affirmative or other defenses available. Defendant reserves the right to assert additional defenses in the event that discovery indicates they would be appropriate. So I feel like we're kind of putting the cart in front of the horse here with the defenses. Sometimes you can put those affirmative defenses in with your answer and it's like, okay, that's great for a heads up. But obviously your affirmative defenses don't have to be put in your answer. You still have, like, depending on your jurisdiction, 30 days before trial or 45 days before trial or 21 days or a week into trial. If you're Mr. Trump, you still have deadlines down the road. Like, you certainly don't have to plead all of your affirmative defenses here, especially when the trial date's likely to be moved. But that's what he's saying here. He's just saying, and I may have others. Like, you don't have to share that. When he no. Oh, I know. That's funny. All right, next and lastly, we've got the prayer for relief, and we need some relief, everyone, because I'm getting a little loopy. So, here we go. Wherefore, defendant, the agency group, prays for relief, as we all do, as follows. Number 1, that the complaint be dismissed with prejudice. Plaintiff takes nothing herein. Oh, that's not very nice. The judgment be entered in favor of defendant against plaintiff for costs of suit incurred in this action and for such other and further relief as the court may deem just and proper. And then there's the demand for a jury trial. Oh my gosh, demands a jury trial on all causes. All right. Also, there's a deadline to put in your jury trial request as well. So our affirmative defenses have a deadline. Our request for a jury trial has a deadline. So I think he's just trying to get it all in one go, but it certainly isn't required legally. Not legal advice, everyone. All right, we made it. I didn't know. I didn't know if we were going to make it or not this time, everybody. I really wasn't sure. There's a lot going on here. There's a lot going on. So it seems like we've got a couple of admissions, and I think one of those admissions could very well be quite harmful in front of a jury, but the other ones don't seem that way. And the lacking knowledge or not remembering, you can absolutely prep for that. One of the greatest things you can do when they're saying, oh, I lack knowledge, is a deposition. Pull them in for a deposition, ask them all of the questions, go through the complaint, basically ask them the questions. What'd you do here? What'd you do here? What'd you do here? And then you've got that deposition to rely on when they're testifying in court. And they say, oh, I don't remember. And you're like, well, I mean, I'm not asking about the day that it happened. I'm asking about what you said in your deposition. Like, oh, I don't remember. Like, well, here it is. Why don't you go ahead and take a look at it? We'll refresh that memory. And then you can tell us about it. So exactly, Willie B. Exactly. So I think that's a good strategy with this case. They're going to have further discovery on it. They've already the judge just put an order, I think, just within the last couple of days to have them go into mediation, and that's always good if you can find an alternative dispute resolution, also known as ADR. That's always a good way to go, and especially when you've got something this heated and intense. If you have a chance to mediate it out, at least you can get some of the issues discussed before you're standing there in front of a jury. What do you think about all of the January 6th FBI investigations being fired tonight and will be investigated? Right, my heart breaks. I'm not sure that there would be a way to completely discredit the criminal justice system than pardoning 1,000 people for being found guilty of crimes, except the only thing that would be worse is by firing the prosecutors doing their jobs, right? I mean, it's atrocious. And fingers crossed that they start suing. I mean, they are attorneys, so if you fire a prosecutor for doing their job, I'm not sure. They could definitely come for you. Yeah, and then too, there was just one that said one woman who'd been pardoned got into, drunk driving accidents and was just sentenced again. It's awful, and the judges all said too that it's awful. But I think we all knew it was coming too. So fired the prosecutors. Yeah, exactly. Which is, again, that's their job. And if you are a prosecutor and you're in that area, it's your job to diligently go forward and uphold the Constitution. They're doing the work. So yeah, and he doesn't like you, and that's what's happening. I mean, we've got the security detail from one of our generals was moved away along with his security clearance, so they took that away. And there's a lot of things going on here, but I have to say we're going to see some more tragedies, in my opinion, by this kind of jumping around bologna sandwich that they keep doing. They keep trying to comply with Project 2025, not understanding the actual repercussions. So this is that find out phase where, unfortunately, I think there will be more tragedies before people recognize how this stuff doesn't work in the practical sense, unfortunately. And I think that's really sad. But again, I think the prosecutors probably had a really good idea. I mean, this is his modus operandi. This is MO. This is like what he likes to do. So we got to kind of keep an eye on that. And I tell you what, the press secretary, I don't know what's going on. Like, at least with Sean Spicer, we knew he was going to chew gum, right? We knew he was going to have gum. We knew he was going to come out and say something ridiculous that we couldn't believe. But with this lady, it's like she looks like she could actually give us some information, with her confidence, and she comes out and, the word choices she's using. But then when you actually listen to the words, it's like, what did she just say? Helping a dictator take over. Right. She's a liar. Well, here's my other question, everybody, too, that, this, to me, the whole situation with the freezing the federal funds, to me, is a lot like what happened in South Korea when they were like, oh, we're declaring martial law for 6 hours. And he had the military come in, or attempted. My gosh, that just cracks me up when you saw representatives out in the streets in South Korea, like, you guys should be embarrassed. I'm going to tell your mother you're out here. The military guys are like, this is like required. We didn't want to be here. It's like amazing. But I think this is similar. He goes forward to put something out in place like, oh, look, I'm a big shot. You got to follow what I say. And then all of this awful stuff comes out of it, right? Because it just evolves into this nightmare. And then he's like, oh, let's take it back. So I feel like it's very similar. Listen this morning, screaming lies on my phone. Oh my gosh, I know. The Constitution is a custom. I know, right? So anyway, when I'm thinking about that situation in South Korea where, like, he's been impeached, I think he's being arrested. There's like some standoff with his mansion. I need to go look at that again. Like, there are some people who are mad about that, and rightfully so. But I keep thinking, we don't really have that kind of military support for Mr. Trump that's so obvious. And so, that's the point where I'm feeling like we're going down a wrong road. If we start to see actual military people being involved in this, we don't see it yet. So I feel like we're still like on the precipice, but we haven't crossed over quite yet. And quite frankly, the way that he talks about the military and the leaders in the military, it's like, what? Come on, man. So we'll see. Hear about Tennessee situation, a felony to vote in a certain way. Yeah, I've been looking through a lot of legislation, actually, from multiple states. And I tell you what, I mean, apparently all you have to do to be a representative is just like, draw something up on a cocktail napkin and submit it to the Legislative Service Bureau, and then boom, we go vote on it. Like, come on, people. Just, waste the court's time coming in and being like, no, that's not how that works. And, I don't have any healthcare benefits. So, dude, what can be done about him gagging the CDC, FDA, because doctors and patients aren't able to see food recalls, etc.? So that's a great question. Boxer Mom, I think we're going to be in another situation where we're going to have some tragedies. I think there will be some tragic repercussions. And then the outcry from that will take it back to like, oh, maybe that was a bad decision. Also, I think it's interesting because those kinds of warnings and that kind of knowledge is for people who just don't have the time to go look everything up, right? Like, is there a website we could just go to? Because before we had these administrative agencies that were like, hey, heads up, don't eat the lettuce. But now it's like, well, where do we go? And so that's going to end in some tragedies, especially with the bird flu situation going on, man. Yikes. Method of voting or the side you vote on? Oh, not sure what you mean. Why does Musk have the authority to look at all the information of the Treasury Department, Medicare, Social Security? Because the President of the United States of America gave him that authority. So, we have to take a look. The security clearance situation, classified documents, all of that stuff is under the umbrella of the executive office. So if he wants to go run down that road, which I don't doubt he will, it's gonna keep going. I remember the huge fight that occurred with Steve Bannon, right? He had security clearance or wasn't given security clearance or whatever. And that was just this huge fight. And so eventually Trump was like, man, I got other stuff to do. But, at this point, he really owes a lot to Musk, right? I mean, we all know that. He owes a lot to him. And so, he doesn't mind giving up some security clearance. It's not important to him if it makes Musk happy, right? Hawk thinks he's going to call martial law and then try to be. So the thing about martial law in the United States, it works different because we have federalism over here. So in normal countries, the leaders like, all right, martial law, so bring in the military. But in the U.S., we've got 50 distinct states with their own sovereignty to some degree. And so for the federal situation to come in and take those rights from the state, it works differently. And because of that, it would be incredibly difficult, actually, to have martial law put into place. The problem, the biggest risk that we run is if the president suspends habeas corpus. If a habeas corpus gets suspended, which means our court system is suspended and it goes through the military courts, that's when we're in some serious trouble. So our martial law over here just looks different than everybody else because, we're weird. But, the term martial law is really triggering. On the other side, I would say watch out for habeas corpus. That's the key. Alonia's people are now embedded in it. Yeah. Oh, absolutely. Absolutely. How do we know he was actually cleared? Well, we don't. We don't. It's just a lot of lies. Ruben, laughter and light, finding food recalls and things. But okay. Oh my gosh. Come on, right? Like, who goes in there and says, well, no more money for kids to have school lunches? That's like evil. That's too liberal to allow them to have food. Like, what the H is that? What the H? It can change elected officials for voting in favor of sanctuary city policies. Right. Well, we've got to be careful with our voting rules because you may feel like, all over the place with the gerrymandering and the voter suppression. True. But there still are some boundaries put into place for voting rights. Not a lot, but at least a few. Trying to get signatures to vote on succeeding. Yeah. I'm not surprised. The cruelty is the point. I think so too. The cruelty and the way to take out their anger on someone else. What they want to do is cause harm to those that are lesser than them so they feel better. It's just classic bully, right? Like, you're really not that great of a person, but if you bully enough people, you can start feeling great about yourself. So it's very, very sad. Separate from the U.S. Yeah, and that's actually not an easy thing to do, to actually secede. Texas is weird because Texas was like its own republic before it became part of the United States. because, you know, Mexico. So Texas is kind of weird. So they're like seceding all the time. But California is a little bit different story. Your career, have you done many civil cases or mainly criminal cases? I have done, when I've actually been arguing in trial, that I've had a jury trial, so it's been criminal work. I have worked civil cases and all kinds of cases, you know, workers' comp. We don't really call that civil cases. Administrative law cases, I guess, is what I would call it. Labor law, contracts, those kinds of things. So I have done that, but none of those cases actually went to a full trial other than a few work comp cases. So primarily, if I was arguing in front of a jury, it was a criminal case. Hmm. Yeah. Nails. Oh, thanks, Big Papa. Thanks so much. What was your favorite case? Oh my gosh, everybody. Let me think. Ooh, my favorite case. I don't know. I mean, someone's hurt, like all of the cases. There's some damage being done, some significant damage. So yeah, I don't know. I would have to say like my favorite my favorite client was actually one of my very first clients, and it was a woman, and she was in her, I don't know, early 40s, and she worked at a warehouse. I probably told the story before, but her whole job was to push huge crates that were on wheels, you know, like big dumpsters, essentially, push them from one side to the other, depending on what's in there. And there were no safety precautions. There was no, you know, OSHA following there. And one day, you know, she's moving one across, and, you know, her uterus fell out. It prolapsed. And she's like, oh my gosh, I spent a few hours in the bathroom trying to figure out what had happened. And anyway, she went through all the medical treatment she needed to, was an amazing, amazing woman, amazing, and had to fight to get benefits because they're like, well, she just had too many kids. Like, I don't think 3 kids is too many. So they're trying to basically blame it on her that her uterus prolapsed rather than the work assigned to her. So it was a lot. It was a lot. So they had reduced any kind of work comp benefits, and then they terminated her. So it was a matter of going back in and getting her full benefits because, you know, I mean, that's a big deal. Plus, they had some bad faith claims in there going after her because of, you know, she had 3 kids. So there were a lot of pieces that needed to be sorted out. But I'd have to say she was one of my absolute favorite plaintiffs because she was so strong. She was so strong. She just came in and was like, what do we need to do? And, you know, loved to talk about her kids. She was, you know, she was short, a shorter lady. It's just the sweetest person. And this was so traumatic for her. So I'd have to say she probably was one of my favorites for sure. 100,000 signatures to impeach Trump. Interesting. That's an interesting idea. Again, though, of course, we have to go through Congress. So we could have a constitutional convention in the states, but it's never happened. Doesn't mean it can't, but it's never happened before. We really have to go through Congress at this point. Yeah, poor lady. Oh, I know, right? I didn't even know that was a thing. You know, I'm like fresh out of law school, like, you know, ooh, yay, look at me. I'm all like a lawyer. And then I was talking to this woman and I'm like, oh my gosh, what happened? Oh my gosh, like what? Oh my goodness. So anyway, she was amazing. And we fought for benefits for her, and she was able to get full benefits, which honestly aren't very much, but you know, we got the best that we can do. Yeah, that was a tough situation. The states can do something to impeach. No, it's Congress. It's Congress itself. It's the elected representatives in the House of Representatives. That you'd have to put articles of impeachment on the floor, and then you would need to get those approved by 2/3, and then the trial goes over to the Senate, where the Chief Supreme Court Justice, so Justice Roberts, would preside over a trial, and you would have to get 2/3 of the Senate to convict, and then you would have an impeachment. That's it. Yeah, I mean, that's it. I mean, each state's got their own set of representatives. So, if you went to your representative in whatever state you were in and you were like, dude, let's do the impeachment, and they listened, that would be great. Right now, what I'm noticing is having the biggest effects on things, truly, truly, everybody, is this complete like outrage. And it's so quick and it's so huge that, I mean, you have to know, like within 24 hours of that federal money freeze, there was so many reports. There were people like, oh my gosh, it was huge. It was huge. We didn't see the same kind of follow up. The only thing would have been the birthright. Sorry, everyone. My brain's starting to get a bit foggy here. But yeah, so the citizenship executive order, that's the only thing that's gotten that level. So I'm definitely seeing if people get loud, I mean, you don't necessarily have to protest, but you can. But wherever people are loud, yeah, that's definitely having a huge effect on this administration. So I think that's very interesting. Yeah, yeah. It'll never happen. Too many Republicans have fallen. Well, that's true. There certainly are a lot. Certainly are a lot. We need to vote every election. Yes. And as many people will tell you, that it has to start at the grassroots level. It just has to. You've got to start getting your communities straightened out so that each state becomes a pillar to support that federal government, but not go down with it. So it's those locals, everyone. It's that school board, your city council, your board of supervisors, your representatives, your local representatives. That's where it's at. I mean, we all look at the president, we're like, oh my God, this is awful. But when you start going local, they can help get protections in place for you. So it's less of an impact, but it also then shows the rest of the United States, like this place, we're not doing this. We don't want to do that. Turned a red seat in Iowa. Yes, after the rep became lieutenant governor. Yes, oh my gosh. And that's huge. I mean, Iowa's incredibly red, as we all have seen, along with a lot of the other states in the area. So, I mean, that's huge. That's huge. Their legislature, along with the governor, has been Republican for a really long time at this point. So that's a huge sign. Can he send 30,000 to Green Bay? Do you mean like troops? Is that what you mean? We have to remember that if anybody's asking for troops, somebody's got to ask for it, right? The governor of whatever state has to ask for help. That's where that declaring a emergency kind of situation comes from, is they will say, dude, we need some help. We need some FEMA. We need some National Guard, whatever. But the state requests that. Oh, the Gitmo. Okay, yeah, that's a good question. So yeah, the state's got to request that. You can't just go flooding it. And people forgot about that because of the presence during January 6th, right? They're like, he should have called in the National Guard. And they're like, he couldn't call in the National Guard. Well, he does actually have executive jurisdiction over DC. He's basically the governor of DC. So you got to keep that in mind. Now, the Gitmo situation, that's really interesting because Mr. Trump had initially written out an executive order refusing to close Gitmo. There are all of these human rights violations, of course, and there's not that many people left in Gitmo. They're just hanging out because they can't go to court, even though they've been in there for 20 years. They're like, well, you don't have habeas corpus, so it's like, oh, thanks, Patriot Act. So yeah, there's a few people hanging out over there being, assaulted, but that piece of land is, it's an interesting location. That would be a very interesting location for immigrants to be put. On the other hand, though, I mean, we don't even have room or humane conditions for, our own people that are citizens that should actually be put into prison. Like there's like 5 people in a room, and it's just like, that's so atrocious. If we're going to make something with 30,000 beds, put prisoners in there, man, because dude, it's inhumane, their living conditions right now. But they're like, well, you don't have the right paperwork, so we're going to go for you. So I don't know. It drives me bonkers that this kind of paperwork issue has surpassed the huge amount of criminal people who are treated like, gerbils in a cage, basically. Like I don't understand how that is a bigger priority than life, but whatever. I'm not in charge. I can't imagine children in Gitmo. Well, we couldn't imagine them in cages either. And I tell you what, that whole situation with the family separation and the children in cages, and the other thing too, people coming in here without proper documentation, they know that this is going on. So imagine, if you will, a situation where they understand how awful it's going to be, but that's still better than where they came from. I mean, it's just, it's heartbreaking. It's absolutely heartbreaking. People are people, right? I mean, come on, man. But I guess people with documents are, I don't know. And ICE is going bonkers too. And I tell you what, anytime you've got law enforcement in a situation where they're basically, you just, open the door and they can go out and run free, they're going to. A lot of our law enforcement are like, well, we don't even get to do anything exciting. And so when you are ringing the bell, it's like, well, let's go do it. So a little bit overzealous, in my opinion. So that's a bit of a struggle as well. It's worrisome, everybody. It's worrisome. I'm not going to say that it's not, because it is. It's definitely worrisome. But we'll have to see. I mean, if they've got land and they've got the ability to somehow turn that to a more humane situation, whatever. But it's all about where the money's going to go. Yeah, I mean, again, we can't even imagine, right? Gitmo itself is a mess. All right, everybody, with that, wow, I've kept you all here really like 2 hours, almost 2.5 hours. Oh my gosh, I shake my fist at this. I shake my fist at the answer. You took up too much time. But we've learned a lot of stuff, right? So that's really good. I will probably put this case then, Miss Lively's case, to rest at this time. We need to wait for some more things to happen on it. So this is a great time to move on to some of our more pressing issues. But I think we have thoroughly gone through this case enough to get both sides to some degree. We could have probably gotten more gotten more information. But right now, again, in the docket, it's slow moving. So we can kind of move on to some of the other pieces. My question is, was it helpful to go through the executive orders or through the proposed legislation? I'm wondering if I should start making that kind of like a regular here, is to go through, these are the executive orders that have come down this week, and these are the proposed amendments, or proposed laws. So I'm not sure if that was helpful, or yes, it was. Okay. Yes. Or if it was, because it's fun to go through and look at these cases, and we can learn a lot, but I think it's also like, we got to kind of make sure that we're watching, making sure that we're keeping an eye on everything. Okay, well, I'll do that then. I think it helps for us to know what's happening. Yes. Well, true. And for me, because I'm not really watching the news or listening to, people, I mean, I might glance over, but it's helpful for me, at least, because I just go to the source. I'm like, well, what are the bills that are going on? What has actually been signed as an executive order? So those things are a little bit more helpful. Remember to take a break. Absolutely, everyone. So I'm hoping to be able to come back on Sunday. Those are one of my favorite nights to come and live stream. So I should be back again then. But until then, have a wonderful weekend, everyone. I'll be back again Sunday and then the rest of this next week as well. So we can chat about some fun stuff. So take care. Thank you all for coming and hanging out with me. It was really fun. Thank you for dealing with my tang situation. I appreciate it. But have a good night. Thank you, of course, moderators. Always, I'm so thankful and appreciative of your time. I will see you all again very soon.